A Supreme Court ruling changed the gun law playbook in America, and most gun owners still have no idea what shifted under their feet. If you carry, want to carry, or even keep a gun in your car, missing this could put you on the wrong side of the law fast. Quick question before we continue. Are you subscribed? Because what I'm about to break down could keep you from making a mistake that follows you for years. Hit that subscribe button right now, because laws like this don't change with flashing warning signs. Most people hear one headline, think they understand it, and then walk straight into trouble. When people talk about this case, they usually say one simple thing: the Supreme Court made carry rights stronger. That's true, but that is not the full story, not even close. What really happened is bigger, messier, and way more important for your everyday life. The court didn't just affect one permit rule, it changed the legal fight over at least 6 major parts of gun law, and some of those changes helped gun owners, while others gave states and prosecutors new ways to fight back. So let me make this simple. The decision I'm talking about is New York State Rifle and Pistol Association versus Bruen. And if you think this only mattered in New York, that's the first big mistake. This ruling changed how courts across the country look at gun laws. Then later, another case called Rahimi showed that the court was not opening every door wide open. That is why almost nobody noticed the full picture. People saw the celebration. They missed the fine print. First thing you need to know is this. The court said the right to bear arms is not just inside your home. That was a huge shift. Before Bruen, a lot of states acted like public carry was some rare privilege the government could hand out only to a lucky few. If you wanted to carry, some places basically asked, "Why are you special?" And if your answer was just, "I want to protect myself," that often was not enough. Here's what just happened. The court said that ordinary law-abiding people have a right to carry a handgun in public for self-defense. That matters because it changed the starting point. Before, the government often started with control. After Bruen, the starting point became the right itself. Now, this is where it gets interesting. The second change was the death blow to special need permit systems. In plain English, those were systems where you had to prove you faced some unique danger before getting an unrestricted carry permit. Not danger like, crime is rising and I want to protect my family. They wanted something more, maybe a stalker, maybe a business handling cash, maybe documented threats. If you were just a regular person, tough luck. The court said that kind of rule goes too far. Why? Because a constitutional right cannot depend on an official deciding whether your fear is good enough. Think about that for a second. Imagine if free speech worked that way. You can speak, but only if you prove your opinion is extra important. Sounds crazy, right? That is basically how some carry systems worked. Here's a hypothetical example to explain this. Let's say you live in a state with rising carjackings. You work late, you stop for gas at midnight. You apply for a permit and say, "I want to defend myself." Under the old kind of system, an official could say, "That's not special enough." Denied. After Bruen, that kind of discretionary rule took a serious hit. But wait, there's something even more important. A lot of people heard that and thought, "Great, permits are over?" No, that is not what the court said. And that brings us to the third change, which is where many viewers get tripped up. Bruen did not wipe out permit systems. It did not say every state must become permitless carry. It did not say training, fingerprints, background checks, or objective paperwork rules are automatically illegal. In fact, the court went out of its way to say shall issue systems can still exist. That means states can still require you to meet clear, objective rules. The problem is when the rules become vague, personal, or impossible to satisfy. So if your state says you need training, a background check, a clean record, and the right forms, that may still stand. If your state says you need to convince some licensing officer that you're extra worthy, that is where the trouble starts. Here's what most people get wrong. They think Bruen was a total win or a total loss. The truth is, it was a reset. It knocked out one kind of carry restriction, but it left room for other rules. That means your state may still control how you carry, where you carry, and what steps you must take before carrying. If you assume Bruen made everything legal, you could make a very expensive mistake. If you're finding this helpful, imagine what you'll learn in my next video about the exact words that can protect you during a police encounter when a firearm is involved. Subscribe now so you don't miss it, because knowing the law is good, but knowing how to handle the moment is even better. Now let's get to change number 4, and this is the part nobody's talking about enough. Sensitive places. Even after Bruen, the court made clear that some places can still be off limits. Schools, courthouses, and government buildings are the easy examples. That part did not disappear. So if somebody told you the Supreme Court said you can carry anywhere now, that is flat out wrong. But here's the crazy part. After Bruen, some states tried to answer the decision by making huge lists of banned places. Not just schools and courthouses. They pushed into parks, transit, entertainment venues, medical offices, houses of worship in some cases, bars, stadiums, and more. In some places, it started to feel like the right existed on paper but vanished once you left your driveway. That triggered wave after wave of lawsuits. Why? Because courts had to answer a new question. How far can a state go before sensitive places becomes a trick to ban carry almost everywhere? And that fight is still happening. Imagine you have a permit. You leave your house legally armed. You stop for coffee, then ride the train, then pick up medicine, then go to a public event, then walk past a government building. At each stop, the legal answer might change. That is why this matters so much. The danger is not always bad intent. The danger is confusion. Let me break this down for you. Bruen did not erase location-based gun laws. It made them harder to justify if states stretch too far. That means some location bans remain strong, some are shaky, and some are tied up in court. So the smart move is not to assume. The smart move is to know your state rules and the latest court orders. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. The fifth change is even sneakier, and this one has trapped people who thought they were being careful. I'm talking about private property rules. After Bruen, some states pushed a new idea. Unless a private business or property owner says guns are allowed, you should assume they are banned. That flips the normal assumption on its head. Most people think, if there's no sign, I'm probably okay. But in some places, lawmakers tried to make the default answer no, unless the owner gave clear permission. That means your legal risk could start before you ever see a warning sign. Here's a hypothetical example. You have a valid permit. You stop at a small store. There's no sign on the door. You walk in carrying. And later you find out your state set the default rule against carry on certain private property open to the public unless permission was clearly given. Now you're not talking about a simple misunderstanding. You may be talking about a criminal charge. That is why this change matters. It turns silence into risk. And it also shows how fast lawmakers adapted after Bruen. They lost on one front, so they shifted to another. What shocked me is how many gun owners still think the only question is, do I have a permit? That is not enough anymore. The better question is, do I have a permit? Am I in a lawful location? And does this property rule change the answer? If you miss that middle piece, you could be legal in the parking lot and illegal 10 steps later. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the people who get these updates before the panic starts. Click subscribe, because one overlooked rule is all it takes to turn a normal day into a legal nightmare. Now let's talk about change number 6, because this one destroyed a lot of bad assumptions on both sides. After Bruen, some people started saying, that's it. The government can't disarm anybody unless there's an exact law from the 1700s. That sounded bold. It also turned out to be wrong. In United States versus Rahimi, the Supreme Court looked at a federal law that bars gun possession by people under certain domestic violence restraining orders. The court upheld that law. In simple terms, the justices said, if a court has found that a person poses a real threat to someone's physical safety, that person can be temporarily disarmed. Why does that matter to you? Because it tells us Bruen was not a wrecking ball for every gun restriction in America. The court did not say modern laws need a perfect copy from the founding era. It said there must be a real historical tradition that supports the basic principle behind the law. That sounds technical, so let me make it simple. Before Bruen, courts often asked, does this law seem reasonable? Does the government have a strong public safety interest? After Bruen, the court said the test should focus much more on the text of the Second Amendment and the history of firearm regulation. Then, Rahimi clarified something important. The government does not need a historical twin. It needs a relevant historical match in principle. That one clarification changed the battlefield. It means courts are still sorting out challenges to laws about dangerous people, age limits, drug users, serial numbers, and more. Some challenges are winning, some are losing. But the point is this. The argument is no longer just about whether a law feels fair. It is about whether history supports that kind of rule. And that leads to the biggest practical lesson in this whole video. Most people think gun law is about one question. Can I own this or carry this? But the real world is more complicated. The actual questions are, who are you under the law? Where are you standing? What kind of permit system does your state use? Are you on public property or private property? Has your state passed a post-Bruen law? And has a court blocked that law, partially blocked it, or allowed it to stay in place? This is the part that shocked me. Two people can do almost the same thing in two different states and get completely different legal results. One person carries legally on a sidewalk outside a restaurant. Another walks into a business under a state rule that treats private property differently and suddenly faces a criminal problem. Same gun, same behavior, different legal outcome. So here's the simple recap of the 6 changes almost nobody noticed. First, the right to carry was recognized outside the home. Second, special need permit systems took a major hit. Third, Objective permit rules like training and background checks were not automatically wiped out. Fourth, sensitive place restrictions survived, but broad new bans started major legal fights. Fifth, private property carry rules became a hidden trap in some states. Sixth, Rahimi showed that dangerous people can still be disarmed and that Bruin is not a free pass against every gun law. And if you remember nothing else, remember this. Bruin made the law more protective in some ways, but also more confusing in everyday life. That is a dangerous combination. Freedom means nothing if you misunderstand the limits and walk yourself into a charge you never saw coming. Laws change fast. Court orders change fast. And the next big ruling could flip your state's rules again before most people even hear about it. Subscribe now, because in the next video, I'm going to show you how to stay legal when the law changes faster than the news cycle. So, what's the big takeaway? Do not rely on one headline, one meme, or one guy at the range to explain your rights. The Supreme Court changed the framework, not just one rule, and that means your carry permit, your location, and your state law all matter more than ever. If this video helped you make sense of the confusion, subscribe and stick with this channel. I spend the time digging through these cases so you can protect your rights and avoid stupid mistakes. And one last thing, this video is for education only. It is not legal advice, and it is not a substitute for talking to a qualified attorney in your state before you act.